service.
Mr. Bandyopadhyay, you have gone through the judgment.
I have gone through the judgment, what has fallen from your lordship, my lord, I really cannot add to it. But my lord, if I may point out a few things
Yes.
which has come to, which I felt, my lord, it might not have slipped your lordship's attention, my lord. But my lord, I'm reading, my lord, from paragraph 18 of my lord Vihan Kumar. That if the police want to prove communication of the grounds of arrest would be based on the diary entry, it is necessary to incorporate those grounds of arrest in the diary entry or any other document. So it can be a verbal communication as well.
No.
If it is verbal, then it must be recorded in the diary.
Yes.
With the grounds. Not only that the ground has been communicated to him. So the ground must be there because the intention of the Honorable Supreme Court is that you cannot bring the grounds later. It cannot be an afterthought.
Whatever it is. But do you have anything to show right now?
But in this matter, only this checklist is there.
The checklist is of compliance of 41(1)(a), basically. This culture.
But I am not on fact. I am not on fact.
You have a remedy. You have seen that definitely.
Yes. But he also has a remedy. That is more important. So if your lordship, kindly take paragraph 20 and 21E. I have ended up marking it, that when an arrested person is produced before a judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance with Article 22(1) has been made. The reason is that due to non-compliance, the arrest is rendered illegal. This is in 20. Then 21E, that when an arrested person is produced before the judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance with 22(1) and other mandatory safeguards have been made. Therefore, they have to raise this point at the when the remand order is being made, not before the writ court. This
and finally, in writ court, release them. You see final order of that writ petition.
In that matter, final order in that, but that I can distinguish on fact. That is a different thing. But his remedy is before the magistrate. That is what I am trying to point out. But the intention, in this, it says that the violation of 22 as well as violation of 21. By violation of 21, anything and everything can be brought in before your lordship on that ground. But when specifically, kindly see these two paragraphs. 20 and 21E.
Answer lies in page number 25. None appears because of the profile of the de facto complainant's daughter.
No, that's on facts. I'm not on fact. I'm on the remedy.
Such a manner that sufficient knowledge should be is important and communicated aid to the arrested person effectively in the language which he understands. The communication must be such that the objection.
Then 21E.
This is which court?
Barakpur court. The order shows seen the forwarding report, arrest memo, medical slip. That's it. No ground of arrest, no checklist.
So arrest in writing is not only to the arrest.
The de facto complainant's daughter is a practicing advocate of Barakpur court. For her, there is an unwritten resolution not to appear for this purpose.
The applicant is cooperate with the trial court solely. The arrest of the hence the appeal is allowed and because
I passed in the year 2023, just a junior at and comment another.
Therefore, the applicant should be put. He could have, but then the writ court is not precluded also, I believe, sir. Is this court precluded?
Your lordship is having plenary powers. Your lordship's powers is absolutely wide. I don't want to argue on that point. Your lordship has power to interfere if your lordship finds that there is injustice. But I am not on that. His first remedy
was before the magistrate.
Specifically mentioned in that judgment where he is relying upon. I have seen
he has not relied upon.
I am relying upon this.
I have. This is my.
As far as the other one is concerned, that is also 27-28 is quoted there. That deals with whether it should be an oral communication or written communication.
But Justice Koteshwar Singh's observation over here must be a written communication.
But
You have concentrated on the first
paragraph
judge. second-
18, if your lordship sees paragraph 18, it says that it can be a verbal communication. But if it is a verbal communication, if I appearing for the agency, I say that I have communicated verbally, the onus is upon me to prove that I have communicated verbally. The onus is not on him or any person arrested. That is what the judgment says. If that be so, it is my duty that onus has to be discharged. I can discharge my onus from the case diary. Now, what it observes in paragraph 18 is that merely if I place a case diary, that is not enough. The case diary must show the grounds why I understand, my lord, so that I cannot bring in those grounds on a next day.
Actually, preventive detention has been incorporated in bail. Earlier, this was in
Yes.
preventive detention cases.
And now, whether I am detaining or I am arresting, the grounds must be communicated, either in oral or in writing. Now, my lord, let them, my submission, my lord, is that, my lord, let
Let
them
it furnish
exhaust,
the- let it
exhaust their remedy. Your lordship may keep it pending, my lord. Let them approach again.
Why should, sir? I'm asking them to furnish the bond. You have a remedy. Have you seen that?
My lord.
Huh? You have a remedy. You have seen that. Where is? So if you have that, you exercise that. If you require that.
Very good.
Your lordship, your lordship would also see.
OC 69.
My lord, this is the judgment, my lord, I was talking about. My lord, this is Madhulimai, paragraph number 9 to 12, specifically on this point. Similar thing has happened. My lord, kindly see 9 to 12.
If you-
As per my instruction today, there is a date of production, my lord. And
19
they have filed the bail application before the
তো
matter.
ওইটাতে রিলিজ করে দিতে বলছে 1969 was before the 1973 code. Thereafter DK Basu came in. From 96 97 onwards there's a series of changes incorporated. The rights which were early, these were in respect of detention. Modhulibai case is on detention, not on arrest. The preventive detention concept has been incorporated in arrest now. So I'd been requesting the state to frame out the rules for that.
But my lord, the other matter is pending for the direction to be passed.
That is a POXO matter. I didn't dare there. That's why I've kept it like that. This is a matter where it can be applied.
And this judgment relates to Article 22 subclause 1. But whether 1973 code or 1898 code, well, whatever it
You were not detained. You were arrested, sir.
arrested,
The detention concept has been
diluted,
incorporated in arrest. That was not there earlier.
there is.
Your production is there.
My lord, as
But
per
the line-
my- there is a date of production, my lord.
But
আমাদের ইনস্ট্রাকশনটা কি?
I am being used to
I-
not, well, that instruction I do not have. But my lord,
Today they have filed a bail
They have-
application as per my.
at least I am in custody and the order taken.
Production order is when?
My lord,
Production order.
My lord, today,
my lord,
today
there
is
is
date of production.
there is
my lord. And they have
production
filed a bail
on
application.
instruction I am
there.
submitting this,
Barak
no
court.
bail application has been filed. But nobody is moving.
No, my lord, today they have filed a bail application, they are moving, my lord. And I am a practicing advocate of another court, my lord.
I'm not bothered about that, sir. We are on a separate issue totally.
Yes.
We are on a separate issue.
No, I am also not going to the
Yeah.
factual aspect.
We are on a completely separate issue totally, sir. We are not on the issue whether somebody is a lawyer, somebody has been injured, whether his merits in the case of the state. That also I have not gone into.
Only prayer, kindly peruse page number 25. That's it. Your lordship would see.
Mr. Bandyopadhyay, I am I'm disposing of this matter and I am giving you the liberty to exhaust the other
Are the remedies available to me?
within the judgment itself.
Well, then, my lord, try to give me some protection, my lord. Anytime they can harass me again. Other co-accused persons are also out of the bar.
I'm not saying anything. I am supposed to release a holding illegal arrest.
due to misconduct, if there is any misconduct, due to that is on the police.
There is no
authority.
misconduct, sir. There is no misconduct. There is lack of literacy. Difference between person must know how to conduct. Thereafter, they will.
Kindly give some protection, my lord. Kindly direct them not to enter the jurisdictional station, my lord.
My lord.
They can harass me anytime. Next month, my marriage is.
My lord,
What is
my lord,
actual
one thing, my lord.
jurisdiction?
My lord,
এই তো আমরা
She
এখানটা
is living in my house.
Eight
She is living in my house.
Not go into all these questions.
I mean, conditions the learned magistrate will give, sir. I will,
This way for the time being, my lord.
Protection, my lord.
Mr.
Because anytime they can attack me.
I believe state is going to take steps. That much, I don't know what your police officers would do.
How they assault me, my lord.
আরে এইগুলো বললে খুব মুশকিল হয়ে যায়।
if she approaches her protection, my lord, it will be looked into, my lord, but
I'm directing police authorities will give you necessary protection. That much. But I'm not, if you go into the aspect of bail, this is not bail actually.
In the meantime, kindly give me some protection.
এইগুলো
my lord.
ফোটে এসে এ করে, এইগুলো
Protection, my lord.
Another prayer is there of mine.
Next month is my marriage is
Let
fixed.
the-
on-
My lord,
they can attack
my lord,
me.
but this is the reason I made the submission that there are remedies before the magistrate. But all these contesting arguments has to be before the magistrate, my lord.
চলে আসুন, চলে আসুন। In view of the judgment, just in view, give.
But I have given the Purokasta also.
In view of the, you got the SCC citation. My SCC was not
My lord,
open.
the SCC citation of the Vian is 2025 SCC online SC
লিখে নাও না 2025 SCC online SC
269
269
and that of
Probably
Purokasta is 2024 volume 8 Supreme Court cases
column 8 Supreme
254.
254 আছে। আচ্ছা, এটা ইলাবোরেট করছি না, ছোট করে দিয়ে দিচ্ছি। ইন ভিউ অফ দ্য আচ্ছা, petitioner has approached the court being arrested in connection with কি থানা?
My lord, New Barrack,
New Barrackpur PS case number 65/25
page 31.
under the relevant provisions of the BNS. Acha, learned advocate appearing for the petitioner submitted that the police authorities, without affording any opportunity under section 35(3) of the BNSS, on the same day arrested the petitioner. Full stop. On the other hand, rebutting such contention, state submitted that a checklist was prepared and considering the reasons assigned or available with the police authorities, arrest was effected and considered necessary. Without going into the merits of the case and the dictum of the Honorable Supreme Court in ওই প্রবীর পুরকায়স্থ versus যেটা আছে and Vihan Kumar versus State of Haryana and Nadar, wherein it has been held that the reasons of arrest and grounds of arrest are two separate entities which are to be handed over in writing to the accused before his application for bail is preferred pursuant to his arrest in the court of the in the court of the learned magistrate. I am of the opinion that since the grounds of arrest in this case were not communicated to the present petitioner, nor there are any documents to substantiate that the same was orally communicated and a general diary entry maintained regarding such communication being made, or in the alternative, any document was furnished before the court at the time that such communication was made to the petitioner. I am of the view that the process of arrest The procedural arrest so adopted by the investigating agency is illegal. Accordingly, the petitioner is entitled to be released. Petitioner would furnish his bond before the learned ACJM Barrackpur, all conditions. So far as the conditions and the terms of the bond are concerned, the same would be decided by the learned ACJM Barrackpur. However, state will not be precluded from taking steps in respect of the uh, would not be precluded from taking steps in respect of the guidelines incorporated in Vihan Kumar versus state. That's in Vihan Kumar or
Vihan Kumar.
in Vihan Kumar versus state of Haryana and Nada. Chalo, with the aforesaid observation.
Some protection.
Magistrate, go to the magistrate.
Yes, I that once we do anything, police will take appropriate step, my lord.
On the other hand, I am giving if the respondent number,
Responding number 5 and 6. my lord.
কোন থানায় থাকে?
two respondents. If the respondent number 5 and 6, this was see when you decide a matter on law, na this becomes a
Other
একটু মুশকিল।
out of the bar, my lord, anything they can attack me anytime.
Remember when you appear for the petitioner, you'll be paid back how? Remember, when you come with boundary wall and all those cases, na remember that. I'll just say alternative efficacious remedy is available which is not maintainable. Just remember these things. You have to tolerate the pressure of your client. Court will not tolerate. No, definitely. If an investigation is going on, de facto complainant is insecure. De facto complainant is a witness to the case. Witness protection scheme 2018 is there. In spite of that, a writ court has got to pass an order.
And I can also add charges if required.
This is creating a scene in court, nothing more than that. Approach is the investigating officer expressing insecurity. The police authority would take steps in accordance after seeking necessary directions from the learned magistrate in accordance with Witness Protection Scheme 2018.